have joined, so we can get started. So a big welcome to everyone joining us today. Today's masterclass will be on IP law in the digital age, with a focus on the tech industry and how IP law will be playing a key role in developments in this industry. It's great to see so many people joining today, so thank you all for your time. We've got a great panel lined up for today's session. We've got Dr. Joseph Lee Nazzini, who is a reader in corporate and financial law at the University of Manchester. He's also our program director for our online LLM in international commercial and technology law. We've also got Ray Su from Tenny Law Firm, based out in Taiwan. He's a specialist in intellectual property law and trade secret law, and also pharmaceutical law. And we've got Nigel Jones, who's a former partner at Linklaters, with a lot of experience in intellectual property and healthcare law too. I'm James. A few of you may have talked to me before. I'm the course advisor for our online LLM in international commercial and technology law. So my role is to tell you a little bit about our courses available online to study and tell you about our LLM. So I'll be giving a little bit more information at the end of today's session about that LLM that we offer, run by Joseph. So feel free to get in touch with me if you have any questions about that. I'll just hand over to our panelists today just to introduce themselves a little bit further and tell us about themselves and their career. If we'd like to start with Joseph, if you'd like to tell us about yourself, please.
So, good morning, good afternoon, and good evening, depending on where you are. My name is Joseph Lee Nazzini. I'm the program director of the LLM in International Commercial and Technology Law here at the University of Manchester. And today we are delighted to have two world-class IP law experts here with us. So Nigel Jones, a scientist as well as a lawyer, who has a wealth of IP law knowledge and experience, having worked as a partner for many years at Linklaters in London, an international law firm. Nigel now is also a consultant and advisor for tech companies. And we also have Ray Shi, also a scientist as well as a lawyer, based in Taipei, in Taiwan. And Ray has represented many tech companies, including Apple, Xiaomi, GSK, NVIDIA, and TSMC, the world's largest semiconductor manufacturing company. Unfortunately, that Helen has an urgent transaction to deal with, so she can't be with us today. But then she has sent me her notes, and then I will try my best to present them on her behalf, and I hope I don't breach her IP rights. So today, the topic today is IP law in the digital era. So we have, the lawyers and representing tech companies here to share with us their insight and experience on a number of issues. So now we have three broad questions for them, and feel free to ask questions in the chat, and if you have any and you can either ask a question in the chat or ask the questions during the Q&A sessions. So the first questions that I have for the, by the way, today the reason that we are having this this webinar is to celebrate the World Intellectual Property Day, which is taking place tomorrow, but tomorrow is Saturday, so we don't want to have the webinar tomorrow, so we are celebrating the IP War Day today. So the first questions for our panelists are, so we want to focus first on the traditional tech companies. So we know that high-tech companies such as ASML, Intel, NVIDIA, they played a very important role in the AI supply chains. And recently, the NVIDIA CEO Jensen Huang said that they want to use AI to design AI chips that run AI. And 2 weeks ago, Taiwan's Foxconn has just showcased its hybrid robot. The hybrid robot leveraging on NVIDIA's platform to to develop their AI models. So as such, the tech companies, they are operating on a global scales. So the question is, what are the IP law challenges that they face? Nigel, you have advised many tech companies, including pharmaceutical companies, on patent filing and infringement litigations. What are the key strategies that tech companies are using to strengthen their patent portfolios in this fast-growing AI and semiconductor space?
Thanks, Joseph, for the question. And just to set a little bit of context, so I have worked for a long time for a number of these big companies. What my roles now are more linked to the smaller startup companies. So I sit on the board of a medtech company based in Ireland. I advise a family office which invests in tech startups, including a number which are very interested in AI. And actually, coincidentally, yesterday spent time with that second group of people debating this very question, and perhaps to change slightly your question, to what extent should they, how do they use patents? I think there's a much deeper question evolving as to whether patents remain relevant and of value to companies around the world, and how is that going to be impacted by the ability of AI itself to generate inventions. And something that happened yesterday, which I've not seen before, is one of the inventors in one of these tech companies arrived with a patent application that AI had written for him in half an hour just before we started the meeting. And the question was, what implications are there for the world of intellectual property and tech companies as a result of AI being able to do the job which historically has required input from highly qualified intellectual property practitioners of various sorts. So I mentioned that by way of context, because I stopped being a lawyer 7 years ago, and so I'm not actively advising companies as a lawyer anymore, but I'm very much involved in these deeper, more difficult questions about how do you protect the inventions you make in this area, and that applies not only to traditional tech companies, but obviously also pharmaceutical companies which are using AI to help them develop tools and so on. And I know we're going to come on to some specific challenges that arise in the future, but just very briefly, and I don't know how much knowledge everybody in the audience has about different types of intellectual property, there is a strategic question that companies need to address, which is, do I keep all this confidential and protect my inventions through the trade secret route? One of perhaps the best known examples of that being Coca-Cola. The recipe for Coca-Cola has never been patented. It remains a secret, which is highly guarded and continues to generate significant profits for that company. Or do I take the risk of publishing what I've done through the patent system and hoping that the patents I get at the end of it will be valid and can create the absolute monopoly? And or do I use any of the other intellectual property rights which are available? Copyright, trademarks, I don't think really are particularly relevant for this. And particularly traditionally, there's been a challenge with software-related inventions that many parts of the world prohibit the granting of patents for pure software inventions, and so people were required to look at copyright. So to in a sense fail to address your question, Joseph, it's very difficult in this rapidly evolving world to address that question, but it is a very live issue for companies all over the world, whether they're startups or major pharmaceutical or tech companies. And the traditional approach of filing patents in the hope that something will emerge, I think is changing rapidly as we speak. The other factor, which many people in the audience may be aware of, but perhaps not all, is if you get your patent, it's valid only for a 20-year period from the date on which you filed it. So the Coca-Cola recipe, for example, had they applied for a patent, they would have faced generic competition in the soft drink industry much earlier than they are now. So a range of difficult issues and some difficult legal questions being grappled with, which I know we'll come back to. But I hope that gives a sort of sense of what's going on in different parts of the industry and how a range of intellectual property rights do need to be considered.
Well, thank you, Nigel. So now the questions also for Ray. So Ray, you have represented many high-tech companies, including Micron and TSMC, the world's largest semiconductor company. Are you able to share with us some notable trade secret misappropriation cases that you have handled, and what are the best practices for identifying, protecting, and enforcing trade secrets in a multinational tech environment?
Okay, thank you, Joseph, and good afternoon to everyone. I would like to share an experience representing Micron Technology, which is a world-famous US-based DRAM manufacturer, and handling this trade secret misappropriation case in Taiwan for Micron Technology and Micron Taiwan in the investigation and court proceedings from 2019 to 2021. You may know that in the last decade, there was lots of the new tech companies appears in China, and these China companies pay much more to hunt to hunt the engineers of the Taiwan tech companies because we are able to speak and read the same language. And given that there are many trade secret cases to be examined in the Taiwan courts. In this case, four former Micron employees who had joined a new established DRAM manufacturer in China after they left Micron Taiwan, they were suspected of illegally using Micron's trade secret for assisting mass production of DRAMs. Those employees were accused that they did not delete or destroy Micron's trade secrets after leaving the company, but also unlawfully reproduce and acquire Micron's trade secrets, such as the specification of the gases for DRAM manufacturing or the employees' training material, and so on. At that time, we have to identify what are the trade secrets at dispute, and to prove that the the four defendants infringe upon Micron's right of trade secrets. For example, we spend much time to collect and analyze the digital information from the laptops to prove that the defendant had intended to copy or modify the target files. Finally, the court found defendants guilty of knowingly possessing and reproducing Micron's trade secrets beyond the scope of authorization in violation of Taiwan Trade Secret Act, and the defendants were sentenced to 2 to 3.5 years in prison, respectively. And the laptops and hard drives, flash drives, and mobile phones were confiscated. And regarding the practice for identifying or protecting the trade secrets in this industry, I think at the beginning you may want to decide that your firm would like to protect your professional knowledge by trade secret or patent. According to a report published by EU IPO in 2017, trade secrets are used by around 52% of patents by around 32% of the innovating firms, and the numbers are much higher for the large companies. The trade secrets is not generally known to the public and normally may be divided to the commercial information and the technical information. And the commercial information includes the information of, for example, client list, cost of the products, and contact information of the qualified contractor. And the technical information includes the information of the technical contents, manufacturing process, formulation of the products. For example, in the Micron case I just mentioned previously, Micron's specific and unique design of the liquid or the gas pipes in the factory could effectively transporting the liquid and gas to reduce the cost for the DRAM manufacturing, which should not be known to the public. So it is a trade. It belongs to the trade secrets. Regarding the protecting and enforcing the trade secrets, I think reasonable protect measures are required to be sufficient to demonstrate the right holder of the trade secret as the intention to protect such trade secret, and the third party is unable to easily access such secrets. Although there is no clear line of the so-called reasonable protective measures and will be decided on a case-by-case basis. But of course, it normally includes, for example, signing an NDA, marking the documents or files as confidential or restricted, or need a password before accessing, and keeping the trade secret in a secure location and can only be accessed by limited and authorized persons. I would like to share an example of one of my clients, which is a manufacturer of the conductive paste of a solar cell. The conductive paste is a composition of many chemicals, and the client keeps the information of the chemical components and the relative amounts in the different locations with different passwords, and only a serial number which may be a part of the password will be disclosed if you have the first access password. That means you still need another authorization, such as another password, which may be kept by the management team of the company to access the complete information of one component of the product. Of course, it depends on what you need. Yeah.
Thank you, Ray. And I also asked the question to Helen, and Helen, as an in-house counsel for an international semiconductor company, and what are the most pressing IP rights issues tech companies face, and how do they balance open innovation with the need to protect proprietary technologies? And Helen's response is, in the semiconductor industry, there's a very specific IP rights protections that is called a master right, and is a way to consider protecting the the intellectual property in the semiconductor industry. In addition to what Ray has just mentioned, trade secrets, other measures. Okay, so now we are going to move from the traditional tech companies to more focus on AI, and as we know that AI is now a disruptor, and we have seen there are tensions between AI developers and IP rights holders. And you may have read the news last week that Meta has been sued by the Wall Street Journal in the US for copyright infringement. And a while ago, last year in December, just before the new year, that we have seen the introduction of DeepSeek to the AI market, and there has been some allegations about IP right infringements related to reverse engineering and distillation, and then 2 weeks ago, and Ray, Taiwan's Foxconn has just unveiled their new robot. It's medical AI, leveraging on NVIDIA's platforms. So I think despite these developments, the EU AI Act is silent on the IP law issues, and we have also seen recently that the UK Supreme Court has ruled that AI cannot be an inventor. So Nigel, what do you think? To what extent do you think that the IP rights holders can and should go in holding AI developers accountable for copyright infringements? For example, we have seen Meta as being sued by the Wall Street Journal for copyright infringements, and if AI can be used as an asset to defend and build innovation, such as as NVIDIA CEO says, using AI to design chips that runs AI. What do you think?
Again, an excellent and highly complex question, and it sort of it depends which side of the argument you're on. So I, over the years, have represented clients who are both alleged to have infringed and are alleging other people are infringing various forms of intellectual property rights, or misusing trade secrets, or acting in violation of restrictive covenants. So just building on what Ray was just saying, in addition to trade secrets, one of the ways in which companies can try to protect their trade secrets, in addition to confidentiality provisions in legal agreements, is to have a restrictive covenant which prevents an employee going to work for a competitor for a certain period after, and that's highly complicated to draft and get right, and a huge amount of litigation about whether those are enforceable or not. But there are various ways in which people can look at that. So as you said, you could, if you want to protect your market position, if you want to create moats around your castle, then obviously you will want intellectual property to be as strong as possible. You will want the ability to obtain patents for whatever it is the invention is. You will want the standard for obtaining copyright protection to be as low as possible. Conversely, if you are being sued by somebody, you will want the opposite. You will want the patent system to be fair. You don't want it to be overly generous. And you will want the threshold for what does or doesn't constitute a copyrightable work, and B, how the standard for copying of a substantial part to be lower. So there isn't a right answer here, and for many, many decades, and it's going to continue for a long time, that there's a debate about patents in the pharmaceutical area. You know, should companies be able to get so-called extra rights? So a pharmaceutical product has been known for a long time. Somebody comes up with a different form of it, or a patch to administer it, and they get another 20 years. Evergreening has been a big issue. So getting this balance right is very difficult. But I do think there are some significant challenges for organizations. I mean, like the Wall Street Journal, they will have to prove that the original works do satisfy the standard for copyright protection. They will have to establish that whoever wrote them did assign them to the Wall Street Journal, and that may sound like a straightforward point, and for where the work is done by an employee, normally it is, but where it's a consultant, a freelance journalist, for example, it's remarkably common for organizations to fail to get that freelance journalist to assign the copyright to the organization. And if they don't, then they won't satisfy the basic chain of title. You know, if you're buying a house, one of the things your lawyers will check is, does the seller actually own it? Well, the same issue arises with intellectual property. And in many cases I've been involved in over the years, there is no chain of title. And if you can't prove that, you've got no basis for suing anybody. So, and then they will have to establish that the amount that the AI company has used is a substantial part, because that's the standard for copyright infringement in many parts of the world. So I think there are many challenges, but and I don't think there's a right or wrong answer, because, as I say, it depends. If you've invested in the Wall Street Journal, obviously you don't want people ripping you off. If you've invested in the organization which is using material from the Wall Street Journal to generate the return on your investment, then you'll have a different perspective. And also different countries around the world have different views. I know we don't want to get onto geopolitics, but there is a big question at the moment about what influence governments should or shouldn't have over courts. Let's just leave it at a very general level. At the moment, that hasn't applied to intellectual property in the US, but there is a very significant risk that it will. And then you may face a situation whereas 20, 30 years ago, many people in the world thought the Chinese government was exerting a significant influence over the courts in that country, and therefore if you were a non-Chinese company suing a Chinese company for patent infringement, you were bound to lose. I'm not saying that was right, but that was a perception. That has changed within China, and query whether it's going to end up in the US instead. So again, lots of really interesting questions. Things are moving very quickly, but those are some of the things that I think people need to take into account. And just coming, but I think we're going to come back to startups in a minute. So I'll leave it for now. Yep.
Thank you, Joel. So, Ray, now the questions for you. We are talking about AI as disruptor, and you are a patent attorney. You have been involved in patent filings for for many years. And so, do you think that AI may be used to help patent lawyers in tasks such as patent drafting? And if so, what are the risks involved in using these AI tools? And now we are lawyers. How can lawyers and also the legal industry then better protect their proprietary knowledge? And we also have our intellectual property rights.
According to my knowledge, there are a lot of commercialized AI tools which may be used for the patent drafting. For example, the soft intelligence, deep IP, or claim master, something like that. But normally, a user could input some short descriptions of the desired technical features and, for example, the invention concepts into an AI system. And the AI system would produce and feedback a draft specification and patent claims in around 15 to 20 minutes. Yes, it looks helpful. However, there are I think at least two risks in using these AI tools. I have read a news article from Wall Street Journal a couple days ago, which entitled "5 Things You Should Never Reveal to ChatGPT If You Want to Protect Your Privacy." And one of them is the proprietary corporate information, include the non-public trade secrets. Given that the first risk is you have to find out the trustworthy AI system for drafting patent specification and claims if you want to use the AI tools, because the technical features and the invention concepts to be input into the AI system normally are the most important technology information of the company, and therefore it should be kept confidential before its publication. For example, the early publication of the patent application after 18 months since its filing date. And so we cannot take any risk if the AI system would disclose our core technical information to any third party. The other one is relating to the copyright issue. There was a copyright case in Taiwan around 10 years ago, in which a patent lawyer produced a patent specification by copying some paragraph of another published patent in the same technical field. And the court found that the said patent lawyer violated the Taiwan Copyright Act. Since I cannot make sure how these AI tools work, it possibly may involve the copyright issue if the AI simply puts the paragraph of the publicized patent together to produce the draft specification and claims. And regarding how can lawyers and the legal industry to protect their knowledge, you may have heard that someone said that lawyers will be replaced by AI in the future. And actually, I have asked a similar question to ChatGPT a few days ago. And you know what? ChatGPT responded that this is a great question, and it told me to avoid feeding proprietary knowledge into public AI models, including ChatGPT. Don't you think this answer is very interesting? So let's go back to the question. Before AI tools become popular, actually, it has already become easy for the people to approach lots of template legal documents, such as contracts, legal briefs, for reference and use through the internet, let alone the AI technology is developing and growing. In this connection, we have to ask ourselves, what is the professional knowledge of a lawyer in this big technology wave? Actually, we lawyers provide our clients with the best strategy to meet the client's need, right? So it would be made based on not only the legal knowledge, but also, for example, economic, political, or business concerns, and I believe it is not easily accomplished by AI tools so far. I'm sorry, but I would say the product produced by AI does not have enough such humanized ideas, and this should be one of our professional knowledge. So please do not limit yourself only to drafting legal briefs, agreements, patent specifications, or other documents. Because I would suggest that lawyers have to learn how to use AI tools to practice laws, at least collecting and consolidating information to strengthen our service based on our humanized professional knowledge.
Thank you, Ray. And then and then I pose a question to Helen, and in relation to DeepSeek, and that's a real competitor to ChatGPT, OpenAI. And we know that, I think 2 days ago, BMW has just announced that they will integrate DeepSeek into their cars in China. So for Helen, my question is, how is China responding to challenges around DeepSeek? Are we seeing the development of new legal frameworks and enforcement strategy around AI and IP, particularly with generative models? And Helen's response is this: on AI, China is very much focused on content security to ensure that AI-generated content does not violate national laws, regulation, and social ethics, and does not pose threats to national security, social stability, and public order. Otherwise, other areas are very much aligned with international approach and standards. For example, in terms of algorithmic accountability, the law requires AI algorithms to be transparent, fair, and non-discriminatory. In terms of intellectual property protections, there are regulations for the use of data and the materials in AI training to prevent infringement on intellectual property rights. And from September 2025, this year, China will enforce content labeling regulations for AI-generated material, requiring all AI-generated content to be clearly labeled to enhance transparency and trust in AI applications. So, as we know, that DeepSeek is a startup, and we know that there are many law tech startups working with foundation models. Some of the law tech that Ray has mentioned in patent filing, but then we have also seen law firms also developing their in-house AI techs through their own innovation centers, for example, Freshfields. And as we've also seen that Foxconn is developing in their own sort of AI models, and some of the medical firms are also relying on platforms provided by big tech companies to develop their own specific AI models. And the big tech companies such as Google, Nvidia, and Intel, they also provide nurturing programs. For instance, Nvidia's Inception and Intel's Ignite, Google's Cloud program for startups. And in fact, as we speak now, Manchester University is actually running a program for Nvidia to nurture startups. And these programs, they offer technical resources, mentorship, as well as market access. However, these collaborations also raise questions around AI ownership, data rights, and also long-term control over their innovation. And you two, as experienced IP lawyers, you have been advising multinational companies. So you may have seen both opportunities and risk involved. And how can startup protect their IP rights. So for Nigel, you wear multiple hats, and not only as a lawyer, but also as a strategic advisor for early stage tech companies. What are the key steps startups should take to protect their IP when developing products on third-party platforms or with foundation models? And how can they ensure they retain control over their core assets when partnering with the larger entities?
Well, just to be clear, I have been a lawyer, but I am no longer a lawyer. I'm afraid it's a caveat I have to put in now for all sorts of reasons. So, but that doesn't mean I've forgotten everything I learned over many, many years. And just before coming to your specific question, it's picking up on something Ray said. I no longer have a vested interest in protecting the legal profession's future business because I'm not a lawyer anymore. However, having benefited from it enormously because it was a really exciting job, and much of what I now do is based on what I learned there, I think it's absolutely critical for a society to have a strong legal profession and people who are able to give advice on the sort of questions we're talking about today. And that can happen at the moment only by having years and years of experience. One of the challenges I see for the profession, whether it's the patent attorney profession or the legal profession, is if many of the jobs that I performed 40 years ago as a trainee solicitor are now performed by technology, how are the people who are as young as I was 40 years ago going to learn the skills that I learned? There's a broader question, because if people aren't in the office anymore, I don't understand how they're going to learn the skills I learned by sharing an office with a senior lawyer, but that's not the subject of today's discussion. So a lot of what junior lawyers used to do is now done by machines and done to a very high standard. I'm not disagreeing with Ray that they will completely replace people, but how are the junior lawyers going to get a job, because many law firms are cutting back on the number of lawyers they're taking on? And I think that may be of some relevance to some people in the audience who are thinking about law as a career or IP. It's a great career to go into, but I think it's going to become increasingly challenging to get into it. And then secondly, how are those people going to get the experience I got over 30 years to be able, when I got fairly senior, to have the confidence to say, I think I know what the answer is here. And that doesn't, and I think that's going to take a very long time for AI to pick up on. But coming back to some of the things I am now currently involved in, which are some startups, the questions are really complicated and really important. So you've got a limited amount of money, you've got a really good idea, and among other things, you need investment. What is the IP story you need to be able to tell in order to get that investment? And this has been a live topic of conversation in the last 2 days for me in relation to two early stage startups I'm involved in. If you spend too much money on patents, people may say, well, that's a complete waste of money because patents aren't going to work anymore for this area. If you don't spend enough, you may not have a convincing IP story. And we had a 3-hour brainstorming session yesterday on, are patents still of any relevance to this particular organization, startup using AI in the healthcare space? And we didn't come to a conclusion. So it's a really difficult and rapidly evolving model, but some really basic things which Ray has sort of touched on already. First of all, keep your stuff confidential, because once you've released it to people, A, they can access it, and B, you then can't get a patent for it. And many, many people are ignorant of that fact. To get a patent, your invention has to be novel. I've been involved in judging competitions where brilliant scientists have said, we've got this great idea, and it was a competition for how great the idea was, but we had to consider whether it was commercializable. And they said, we announced it at a conference in Sweden last week, and we're going to file our patent application next week. Well, their patent is invalid because they've disclosed it to us. So the first thing is be very, very careful who you share the information with, particularly when you're contemplating partnership agreements or potential investors. Anybody apart from your lawyers are safe because they're bound by obligations of confidence. You can talk to them about it, but anybody else not. Using an AI tool, as Ray has said, really dangerous, because if by typing in something about your technology into an AI tool, for example, to help you to draft a patent application more quickly and more cheaply than through a patent attorney, A, you've disclosed it, and B, whatever it produces won't benefit from legal professional privilege. And that's perhaps another important point that not everybody may be aware of. Communications between a client and a lawyer are subject to legal professional privilege. No one is ever supposed to be able to see those communications. If you ask AI for legal advice, as far as I'm aware, there is no case anywhere in the world which says AI is eligible for legal professional privilege. So if AI says, for example, in a freedom to operate situation where you have a product as a startup company, you need to check whether there are any existing patent rights out there which might prevent you commercializing. It's very common to do something called a freedom to operate opinion. The contents of that are covered by legal professional privilege. If you've got an AI machine to do that, it would not be. And no properly qualified entity will ever give you a clean bill of health on freedom to operate. There will always be caveats of some sort, and you have to be very careful about that. So I think that there are some basic things. Look after your technology. Secondly, look after your people. Because ultimately, if it's in somebody's head and you don't treat them well, you don't pay them market rates, you don't treat them properly in all sorts of ways. I'm particularly interested in well-being in the workplace. And they walk across the road to your competitor, yes, you may be able to sue them. Yes, you may be able to enforce a restrictive covenant, but actually the horse has bolted. They've got the information, they've taken it. There are some countries, obviously Taiwan is one, where that's a criminal offense. In most places it's not. That would be a civil action. So I think, as Roy said, NDAs, non-disclosure agreements, really important. Bigger organizations often won't sign them. My suggestion is, in that case, then you need to find somebody who will. Look after your technology, don't put it into AI tools. And thirdly, look after your people. Those would be my sort of basic practical suggestions for startups when it comes to protecting their inventions.
Thank you, Nigel. And Ray, you have been involved in many M&A, sort of in IP-heavy transactions. What advice would you give to start up, participating in incubation and innovation programs run by big tech firms? Yeah.
Actually, this is a big question. Yes, the startup will collect funds and technical assistance from the big tech firms and may be able to announce to the public the cooperation with such a big company, which may be a kind of the reputation of a startup. And it absolutely would be helpful. But the startup usually would face some difficulties when participating in incubation or innovation program run by the big tech firms. What I'm going to say are not relating to legal issues, but could be your reference when you participate in such programs. For example, in the program run by the big tech firms, there normally are many projects in this program. So a startup cannot make sure how important your project is to the big tech company. Even your project and idea may be used for the next generation product. You may be one of the choices, and the big tech firm need not to focus so much or pay much attention on your project unless you are able to solve an urgent problem for them or you are much more better than your competitors. So my suggestion is we have to keep the communication with the big tech company open and smooth to make sure that the big tech firms will understand how good your product or your idea is. The second example is normally a project in the program would continue for a period of time. For example, at least 6 months, 1 year or more. During this time period, the interest person, which may be a specialist or the project manager of the big tech firms, he or she may leave the firm or be transferred to another department. And the successor cannot completely understand this project in time, not to mention that she or he may not care about your project. So my suggestion is please do not contact the in-charge person of the project only. You have to try to connect the other persons in the big tech company as many as possible. The third example is the big firms do not necessarily understand the customer's need, although it is a famous and big company. Sometimes even they present the information on your project to the customer. Nothing will happen if the customer does not have any interest. So my suggestion is it is important to everyone, including every startup companies, that your product and idea should meet the market's need. And so the startup should know the end user's requirements, and the startup company's own survival should not depend on the big tech firms too much. Yes.
Thank you, Ray. And then I also posed a question to Helen, and because Helen is an in-house counsel at a multinational company that acquires startups, and then I was asking her, so she is able to see it from the other side, and I asked her what makes a startup's IP attractive or risky from an acquirer's perspective, and Helen's response is, well, startups should make sure that they don't disclose too much about their business model and their core technology before signing an NDA, non-disclosure agreement. Because once the information is leaked, it is out in the public. So they should try to protect their know-how through various IP forms, patent, trade secret, and a copyright. But she also said that the numbers of IPs are not necessarily the key issues or factors for the investors. Investors may care more about who you are, why they should invest in you, and not others, and also what difference that your invention can make to the world. And that's the Helen's response. So we encourage our audience to ask questions in the chat, but before that, we have also encouraged them to send in their questions. I think, James, you have collected some questions. Maybe I hand it over to you.
Absolutely, yeah. Thank you, Joseph. Thank you for those insightful discussions there as well. Yeah, we have had a few from our signups, and there's also some questions in the chat, so we'll do our best to get through all of these. There was a question related to what Joseph mentioned earlier about the UK Supreme Court ruling that AI cannot be an inventor of a patent. So are there any similar rulings in other jurisdictions, perhaps in Asia, that have a similar restriction on AI being an inventor of a patent? Does Ray, do you want to maybe take this one? Anything in Taiwan that would restrict that?
Yeah, the story is in 2019, a man, he is the Dr. Stephen Taylor, filed 2 patent applications with the patent offices around the world. And one is relating to a container for food or drink. The other one is a device and method for improving humans' attention, in which the inventor of the 2 applications is an AI system named DABUS. You may be aware that almost all the courts and patent offices around the world, including most countries in America, Europe, and Asia, including Taiwan, but except South Africa and Australia, require human inventors because according to the patent laws, the patent should be a creation made by the human being. So almost all Dr. Taylor's patent applications were rejected. Yeah.
Okay, thank you for that. Yeah. So other questions we've had. There was a couple of questions related to creative industries and entertainment industries. So there was one regarding IP law in the entertainment industry, and then one about the creative industry. So here there was one about Japan is considering a ban on AI generated Ghibli style images. So I believe that's like the anime style images to protect copyright of creators of that sort of imagery. How do you feel about this approach for protecting that kind of copyright, banning that sort of AI generated content? To Ray as well, please.
Yes, it is a fun topic. ChatGPT's creation of Studio Ghibli style image or picture shows AI's power of creation, but also raises a new copyright problem. For example, I have learned from the media a picture with the Ghibli style, which is relating to the argument between Trump and Zelensky in the White House. It looks like an animated picture having the Ghibli style. Of course, the photographer who took this picture owns the copyright of this picture. However, as we do not ensure if an animation style could be protected by the copyright laws or not, someone has raised concerns that OpenAI may have scrapped the popular Japanese anime studio's copyright works without permission to train its image generation tools. And and as you mentioned, Japanese lawmakers are questioning if they can take any legal action against AI art models to do this. Um, since I did not have the chance to study this issue, I'm afraid that I do not have sufficient information so far. But my only comment is, since it is the same or similar style rather than direct reproduction of the original creation, we do not know if such kind of claim, if any, of the copyright regarding the style would stand or not. But as Japan is considering to ban AI generated images having specific style, it means that they would like to find a way to solve this problem. Yes, it is absolutely it is a good approach to in view of the new AI technology.
Thank you for that, Ray. Yeah, it's an interesting one actually. That's sort of the idea of yeah, because it's art effectively, isn't it? And I mean, copyrighting art and things. It's interesting.
James, could I just chip in there?
Sure.
And I think it's sort of it's building on a point I made earlier. It depends which lens you're looking at this from, and arguably it's an existential question, because if something isn't done to limit, to protect the creative industries, the entertainment industries, the people who sing, act, write, and so on, it will disappear.
Mm.
If that's what society wants, fine. But if it's not, then these issues do need to be grappled with, rather than assuming that it's clearly right to allow AI to do these things. So I'm not saying AI is a bad thing. Clearly it's not per se, but it does have potential consequences which people do need to think about. And it sort of goes back to another point. There was so the fact that you can get IP protection, or that AI can do something, doesn't mean that it's good. I remember 10 years ago, I'm involved with an orchestra. I don't play, we support it, but that they performed two pieces. This is an early music industry, so cellos and double basses and string instruments. And they played two pieces, and the audience had to vote as to which one was generated by AI, and it was very close. So most of the audience couldn't tell the difference. And then the musicians were asked, and they all got it right. And the reason was AI had never played a cello or a double bass, and it was virtually impossible to play the piece of music in the way it was written. So in that example, what AI generated was not useless, but certainly not as valuable as Bach, the original composer of the original work. So again, I'm not saying it is, but and then if you just say it doesn't really matter, no music should ever be subject to copyright. Anybody, any AI tool can generate whatever it wants. People just need to have clarity about where that could end up, and be confident that that's where they want it to end up, but before going too far down. So it's a big sort of philosophical point, but I think is important to keep in mind. It's not just dry black letter law we're talking about here. It's real people and society's way of living that are at stake.
Absolutely, yeah, and it's the future of some key industries for sure. There was another question here about quite a technical question, this, but perhaps Nigel, with your background in medical related law, might be related to you. So it's in terms of specialized AI models for therapeutic purposes, does a selected database used for training that AI model make it unique?
I assume the question is, does it qualify for patent protection? And the word unique doesn't formally come into that, but would it satisfy the requirements for patentability, namely novelty, inventive, not obvious, and industrial applicable? And most importantly, is it outside one of the excluded fields? And I think that may be one of the key questions here, because in many parts of the world, computer software per se cannot be patented. The test is less strict in the US than it is in Europe, and there are plenty of patents in Europe which have been granted for tech-enabled inventions. So the short answer is maybe. And actually, that may not be very helpful, but actually, those are the standards. So is it a completely new data set or way of addressing the data set? Is the way in which that's been done, would it or would it not be obvious to a person skilled in the art at the relevant time? And does it or doesn't it? Does it fall into the excluded category, in which case it would not be patentable, or based on the case law in the relevant jurisdiction, would it fall outside that? So I think it certainly is worth considering filing a patent application and getting up-to-date advice from someone who is day-to-day filing these applications and keeping up to date with the law. And in fact, the conversation I was having yesterday was almost identical to this situation, except it was about a diagnostic tool using AI to analyze a particular body fluid to diagnose a particular condition, as a companion diagnostic for a pharmaceutical company which has developed a product for treating the underlying condition. So you can only treat a condition effectively if you can diagnose it in the first place, and that's where companion diagnostics come in. So I hope that's of some use to the person who posed the question, but it's not straightforward. I guess otherwise they wouldn't have asked the question. But
yeah, absolutely. Thank you for that, Nigel, and thank you for that question as well. So I think that pretty much covers all the questions that we've had. If anyone in the audience does have any further questions, you can always email them over to me, and we can do our best to get back to you on those. But we are coming to the end of today's session. So I will just finish off today's session by giving everyone a little bit of information about the University of Manchester's opportunities to study some related topics that we've discussed today. So Joseph is our program director of our online LLM in international commercial and technology law. So this is a really exciting LLM that's been running for a few years now, and we have an intake this September. So if anyone in our audience is interested in studying with us, we do offer this LLM, really pioneering some of the content in there, really interesting legal discussions going on, and it'd be great to see if anyone is interested in partaking in this LLM. So it's an online program, and you will study part-time with the University of Manchester. It will take 24 months to complete part-time, so you can do it alongside your work commitments. Our next enrolment is in September, and we also do offer an early application discount. So if you are interested in applying, make sure that you apply before June 30th to qualify for that discount. There are also some other bursaries and scholarships available if you've studied with the University of Manchester previously, and fees can be paid in instalments as well to help spread the cost of the course. So yeah, like I said, it's a really interesting LLM, and some of the topics discussed today are taught on this LLM, and you can learn more about the growing field of technology law and how it might look in the future. So feel free to contact me at studyonline@manchester.ac.uk if you have any questions about the course. Also, if you've got any questions that you didn't manage to ask in today's session, you can also email them across to me at the same email address. You can also check out our course webpage at manchester.ac.uk/techlaw. So that will take you to our course webpage for you to learn more about the course, how to apply, and any other information you might need about that. So any interest in that, feel free to get in touch. I'll just run a really quick poll based on today. Just a couple of questions there. If anyone has the time at the end there to answer those, if they found the webinar useful, and if you'd like a consultation to learn more about our LLM in international commercial technology law, feel free to tick that, and I'll get back to you to arrange that consultation with you. So yeah, that pretty much brings us to the end of our session. A big thank you to Ray, Nigel, and Joseph for all of your discussions there and your inputs on some of those really fascinating topics of future IP law developments. Really interesting to hear about that. And thank you everyone for joining us. Really great to see a great turnout today. So get in touch if you have any questions about today's topics or our LLM. So thank you all, and bye for now.
Thank you. Goodbye.